Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming attorney Maureen Scorese from our Edison, New Jersey office. Hi there, Maureen, and welcome.
Hi, Arianna. Thank you for having me.
Thank you so much for being here. Today's topic is on employment law, restrictive covenants, and the FTC Final Rule on non-competes. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have questions, please comment them below or email us anytime at info@chug.com so we can help you out. Let's get right into it, Maureen. I want to start with non-compete agreements. Can you tell us what are the key components of a non-compete agreement and how can employers ensure that they are enforceable?
So, non-compete agreements typically restrict an employee's ability to work, sometimes while they're still at that employer, so they can affect their current employment and not allow them to do side jobs. But oftentimes they're focused on restricting the employment of the employee after they leave that employer for a set period of time. So it oftentimes would be in the same field of what they're doing for that business.
What about non-solicitation clauses? How do non-solicitation clauses differ from non-compete agreements, and when should employers use them?
Okay, so that's a good question, and sometimes gets confused or all flushed together in some people's perception. So the non-compete limits the employee on where they can work after leaving the employer or the field of work. And if they were to do a startup business, if it was in the same field, it would prohibit them for some period of time from being able to do that. A non-solicitation agreement can be varied. It usually deals with that employee who's leaving not being able to solicit the former employer's customers, clients. Sometimes it can also be focused to limit that former employee's ability to offer a job to colleagues or other employees at that place of business that they just left.
Wow, interesting. So I want to touch on confidentiality agreements. Can you share with us the importance of confidentiality agreements in protecting sensitive business information?
Sure. So confidentiality agreements are another, they're often also called non-disclosure agreements, NDAs. And so they often are used by businesses to protect their confidential information and or business plan information that wouldn't be publicly available. That can include customer lists because not everybody knows their customers. It can involve trade secrets and how they operate, or the secrets behind their business product or service, and just any specific way of doing business that they use on an everyday basis. So oftentimes employers don't want their employees leaving and then sharing all that information that's specific to their business, their products and services with the new employer. That can create conflict. It can result in a competitor that employee goes to then be learn from that knowledge set, which just isn't fair. So
It does sound like
oftentimes,
it's great for businesses to protect themselves with these, right?
absolutely, absolutely. So you want to be careful because employees come and go. Some stay longer than others, but overall, that business has a lot invested in what they're doing, and so it is important for businesses to have confidentiality agreements to be able to protect their business going forward as the employees may decide to leave. There's also sometimes non-disclosure agreements. I've had some customers, clients come and want to protect training or investment that the employees get on site. And so that's that type of training of like learning a new source code or a way of writing code, things like that. That's more along the training lines. So while there can sometimes be a mix of how do you handle with the employee just learning the trade on the job that happens to be the employer's business, right? So there sometimes are gray areas as well, and they're sometimes better left for employment policies, so that if an employee gains skills on the job, that those skills can be applied elsewhere. They're not confidential information of the employer, but you would have to address that type of information as far as that training that they get in a different manner, not in a confidentiality agreement.
Absolutely great points there. And if you are watching this and need help drafting one of these, reach out to us. We'd love to help you out. Let's dive into state law variations. So how do state laws impact the enforceability of restrictive covenants, and what should employers be aware of when they're drafting these state law variations?
So the states all have very different laws. Each state is specific. You can put them in a bucket of some that permit reasonable restrictions, and then those that don't permit them. So there's different buckets of states that you can kind of group together. And then there's some that permit them with a lot of restrictions. So non-competes wouldn't be applicable to everybody, but maybe those people who earn more than $150,000 and have supervisory positions or are implementing policy, or, you know, there's that each state is different. So you really need to pay attention to where your employees reside. For those remote workers, if they're not in person, you have to look at the state where they're residing and then, you know, find out what the laws of that state say.
Got it. So I do want to dive into the FTC final rule on non-competes. I know we've talked a little bit about the FTC and what potentially could happen with these, but can you explain the FTC's final rule on non-competes and the rationale behind it?
So the final rule is intended to be a ban on non-competes going forward. The idea was brought about through President Biden's administration as a way to create more innovation, more startups in the business marketplace, and better wages for the employees. There have been studies out there that are saying that it's suppressing people's wages, it's suppressing some innovation. And so this was one of the outputs of one of his executive orders. So the FTC got to working on this. So the FTC published this about a year and a half ago, this new rule, to ban all non-competes except for senior executives, and then to put a limit on the ability to have non-competes going forward. It's very far-reaching, very drastic change from the current landscape, and it seems to be a little too much for everybody to handle right now. There's a lot of nuances when you actually read the rule about maybe in this situation, but not in that. You really do need to read the rule to fully understand whether it applies to your situation. But recently, the Texas court 2 days ago, there's been several litigations, and it was just struck down on Tuesday. So,
Oh, wow. Interesting. So how will the final rule affect employers who are already currently using these non-compete agreements? Do they have to make changes? What does that look like?
So prior to Tuesday, I would have said, yes, everyone has to get ready. You have to provide notices to all your employees by September 4th, that they're, depending on their position, right? And the interpretation of the rule to your employees and their job responsibilities, all of those non-compete agreements would be no longer void and enforceable. However, and so that was one thing that was a big deal that everybody was trying to get ready for, and then trying to understand how to go forward with changing the language of those positions where it was still permissible, right? But right now it's all on hold. It's in litigation, and we can talk more about that in a little bit. Okay.
Okay, perfect. So what does the FTC's rule mean for employees who are currently also bound by non-compete agreements?
So that's if they were currently bound by non-competes, it was going to cancel them for the most part, making them non-enforceable. For most of them, not all, senior executives would still have to, those agreements for senior executives would still be enforceable. So there's language that it's maybe these people, but not those. You definitely, it's hard to say a big bucket. You need to read the rule and really figure that out. But again, it's on hold right now. So there's no changes that will be effective until the final decision comes out of the courts.
Okay, so will the final rule apply retroactively to existing non-compete agreements?
We're going to have to wait and see what happens in the court system. So there was going to be some retroactive applications so that those people who were currently under non-competes would no longer be effective. But right now it's all on hold.
Got it. Okay. So what about legal challenges? Are there any legal challenges or exemptions to this final rule that employers should be aware of?
Right. So that's what I was referring to earlier. There were several lawsuits filed when the new rule came out in April. And the one particular case in Texas is the one on Tuesday, where obviously it was challenged, briefing went on back and forth. And the judge in the Texas case just struck down the FTC rule and made it a very broad application. So previously in July, they had limited and did an interim decision. But on Tuesday, the judge issued an order that was very broad ramifications, striking down the rule as not improper, that the agency exceeded its authority in making the rule. And so that's where it stands. That impacts everybody across the country. The FTC hasn't made a decision yet on whether to appeal it. I would expect them to, after all the time and effort that was put into the drafting. I wouldn't be surprised if they were to appeal it. An interesting piece of information is last month, there was a similar lawsuit where an order was issued denying the request to strike down the FTC rule. And so that judge held the FTC rule as proper and stated that the FTC was within their authority to issue the non-compete ban, right? So we have two district courts in different parts of the country that have come out differently. And so this is really what we see in litigation like this, is that the FTC would appeal and it'll end up at the Supreme Court at some point, depending on what happens at the next appellate level. So it's interesting. And then of course there is one other case that was noteworthy to mention in Florida, that the judge in that case also blocked the FTC rule, and but it was very specific for the plaintiffs in that case. So for the case specific circumstances, the judge limited the order to not apply and enforce the FTC rule in that specific scenario, whereas the Texas court made a very broad reaching order, just striking it down completely.
Wow, so interesting. We're definitely going to have to stay tuned to see what comes about these changes and what's next.
Yeah, it's a big deal for a lot of businesses because there are a ton of non-competes out there.
Absolutely. I do want to pick your brain a little bit on what are the best practices for drafting restrictive covenants that are likely to be upheld in court. What do we need to know? What do you suggest?
So this is a great question because I see a lot of non-competes that come across my desk, and sometimes you wonder who was drafting it, because some of them are just so broad. You're like, this isn't enforceable anywhere, right? Why have a provision that automatically is going to involve you in turmoil in any litigation because it's not restricted in any way? It's just overly broad. So as a best practice at a high level, I would always say to keep it reasonable, what you're trying to restrict, keep it related to your business interests. What about your business are you trying to protect? And craft the language so that it's going to protect your business interests. And then keep it fair. as much as you want to protect your business, you have to also understand that your employees should also be able to find comparable work. Their only option after leaving your business shouldn't be to work at the local drugstore or the local fast food chain. They should be able to leave and move on somewhere else and engage in comparable work. So that would be unfair to them if they couldn't, based on the language. So on a more specific level, and the ways to keep it reasonable and related to your business interests is to look at the geography of where your business is located and where you operate. A duration, like if an employee leaves, when is the most likely possibility of damage? Is shortly after they leave, because they still remember everything from their employment. So maybe it needs to be 6 months. Maybe the non-compete needs to be a year. The shorter it is, the more reasonable and enforceable it will be. And then the other idea for restriction is to consider the scope. If you can define the field that this person was working in, the type of business, if it makes sense for you to be able to define that as well, it'll help it to be enforceable and understood as written. And then you don't have to have the attorneys and pay the attorneys to argue about what it's supposed to be protecting them in enforcing it in court. So those are preliminary recommendations. There's also, as far as restrictive covenants, the use of non-solicitation language is another angle. So it's not just the non-compete provision, but if you're more worried less about where they're going to work, but more about the employee taking your clients, then you don't really need a non-compete necessarily. You need a non-solicitation provision in there. So you can balance out and through this discussion, figure out the best way to protect your business interests.
All such great points. And if you are watching this and need help with this, let us know. We'll connect you with Maureen. She's absolutely wonderful. And, you know, as you saw, she did mention some great points to keep in mind when you are considering drafting this. So how should restrictive covenants be tailored to different roles within a company? For example, executives versus rank and file employees. What does that look like?
So that is a really good question. And it's not something I can answer in this type of a setting because it's really specific to the type of business. And as you mentioned, the different roles, right? It's specific to the type of role, the roles of your employees and where they are in the business, who they're interacting with, and what access they have to customers, clients, confidential information. Because the whole idea of the non-compete is to protect that part of the business. And so it will vary with the business. It'll vary with the marketplace, right? And where your competitors are, because you're trying to protect against unfair competition, right? With your employee leaving with your information. It'll vary with the state where your employee resides that's leaving. So as far as tailoring the agreement, it's never one size fits all. It depends. It's best for each business owner that has these concerns to find an attorney to speak with and let that attorney get to know your business so that they can better draft the provision to be enforceable for your situation.
Okay, good to know. I'm curious about severability clauses. Do you have any information on how severability clauses can help protect the enforceability of restrictive covenants?
So typically the severability clauses are saying that if one part of your agreement is found to be invalid or non-enforceable, the remaining terms stand. So if your restrictive covenant provision was for, say, 6 years and was to span the entire US, that would be unenforceable. If it was limited, and so if there was some other part of that non-compete that the court found enforceable, then he would just strike out using the severability language, right? The parties are agreeing that if some part of that agreement is found later on to be not enforceable, the remaining provisions stand. Okay, so you can still keep the agreement in place. As far as other terms, confidentiality, that would still remain in place. If there was a non-solicitation provision that was found to be enforceable, that would be in place. But the non-compete that is unreasonable, that would be struck out. Or depending on the state that you're in, the courts may at times revise it to be enforceable if the attorneys come forth with sufficient arguments and evidence to show what would be a reasonable provision. But again, not all states allow that. It depends where you are.
Wow, really good to know. I do want to touch on what the legal landscape will look like post FTC rule. I know we don't have too much information, but anything you can provide, or maybe we have to wait for this information. But what steps should employers take to review and revise existing non-compete agreements in light of the FTC's rule?
So several months ago, I was having a different conversation with clients saying, oh, we have to review, you're going to want to strengthen other parts of your agreement. Maybe if you don't have a strong non-solicitation provision, then just you're going to have to scrap the non-compete. Let's protect your information through NDAs or non-solicitation. And now it's just everything's on hold. So it's always a good idea to review these terms, just given how I think it's really easy to make them overly broad. But it's all on hold right now with the FTC rule, and nobody knows. Right now, it's not going into effect. So there's not a whole lot that you have to do.
What about the state versus federal laws? How should employers navigate conflicts between state laws and the FTC's federal rule on non-competes?
So the right now, because the FTC final rule on the prohibiting the non-competes isn't going into effect, there's nothing to worry about. But you still need to comply with the state laws no matter what. And then and one way to address that in an efficient way, rather than having a different non-compete agreement or for each state, would be to have a rider that would list out general language and then adding at the end for the different states that have laws that prohibit or limit its applicability to certain types of employees, to then list it out state by state, those exceptions to its enforceability. Because you should be giving your employees notice in those states whether or not it does apply to them.
Okay, those are some good things to keep in mind. Regarding litigation risks, what are the risks of litigation for employers who attempt to enforce these restrictive covenants under the new legal framework if it prevents it?
So the litigation risks under the FTC rule now are on hold as far as getting dragged into court, but or brought in before the agency for violating the rule itself. But there are other ways the FTC may bring in and be reviewing an employer's business and the enforceability of their non-competes. So there could be some case-by-case situations that the agency may be looking at. But for now, I don't see any, I see very minimal litigation risks.
Okay, good to know. So what about alternative protections that are out there? What alternative strategies can employers use to protect their business interests if non-compete agreements are restricted or banned?
So other ways would be the use of non-solicitation clauses to those can be crafted to specific customers of the employer, that the employee leaving wouldn't be able to approach them or for business through for a certain period of time. Again, those would still need to be reasonable. They can't be forever into the future. And then also the non-disclosure agreement is another way to maintain the confidentiality of the business information, whether it's trade secret or business practices or client lists.
Wonderful. So I have one more question for you. I know you're busy and we're almost out of time here, but I do want to ask you one more thing. How can employers stay informed about ongoing changes in the law regarding restrictive covenants and non-compete agreements? Where should we be looking?
So if you're a large employer operating in many sites, it's a lot to stay on top of, but the state laws do come out, do get changed on employment laws, not just restrictive covenants that affect employers. There's a lot of employment laws that are changing all the time with the equal pay, Act in New York, some cities as well. It's not just states. We look at states, but places like New York City have specific wage laws that you have to comply with. So it's you should always have a list of the states where you have employees, and then try to stay abreast of any new laws affecting employment from those different states. You certainly for the FTC rule can follow the FTC website or sign up for alerts from that webpage. And then also we often we have on our website many articles throughout the year. We put up articles, different attorneys and staff will help put those together to alert our our clients and others about changes in the law. So you can check there as well.
Perfect. Thank you so much for sharing that with us. And yes, definitely follow up with our blog and sign up for notifications. That is all we have time for today. So thank you so much, everyone, for joining us. A special thank you to you, Maureen, for sharing your insights and all of this wonderful information for us. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, email us at info@chook.com. Let us know what topic you want to see next. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again for joining us. Thank you so much, Maureen.